Welcome to another week of business law. This week we're going to be discussing Chapter 20, Relationship with Third Parties. Very, very important because contractual rights, or some contractual rights, actually do affect third parties. So there is a very specific relationship with third parties in general. So what are we going to talk about? We'll talk about principal, or the relationship of principal and third parties. Within that category, we'll talk about contract liability of the principal. We'll talk about tort liability of the principal and also criminal liability of the principal. Then we'll talk about the relationship of the agent with third parties. And we'll talk about the contract liability of the agent, the tort liability of the agent, and the rights of the agent as against third parties. So let's first start talking about the relationship with third parties. So the purpose of an agency relationship is to allow the principal to extend his business activities by authorizing agents to enter into contracts with third persons on the principal's behalf. We could never do business if it wasn't for agency law. Agency law allows, again, a principal to hire a person to act as that person's agent. And again, this becomes very important and very relevant in business entities because the law recognizes the entity as a separate person. However, obviously, an entity is not a person and cannot act on its own behalf. Therefore, someone, whether it's an officer, a director, or a real person, has to act on the entity's behalf. And so that real person is going to be the agent. And that agent will be dealing with third parties in general. And so that's really the purpose of the chapter, to discuss those relationships. Again, without agency law, we would not be able to engage in business transactions. So what's the relationship of the principal and third parties? In particular, what's the contract liability of the principal? When we're talking about principals, there's actually three different types of principal. We have something called a disclosed principal, and that means that the third party knows who the principal is. So they know that they are dealing with an agent, and they know the identity of the third party. An example of that would be, a very common example of that actually would be a real estate transaction. So let's say I want to sell my house. I hire a real estate agent to sell the house on my behalf. And if you're the buyer and you're dealing with the agent, well, you know that the agent is actually acting on my behalf, and you'll know my identity. You'll know exactly who I am. So that would be an example of a disclosed principal. Then we have something called an unidentified or a partially disclosed principal. And that, in that type of relationship, let's keep using my real estate transaction here. You know that you are dealing with an agent, so you know that there is a principal, but you don't know who that principal is. And we do see these types of transactions quite a bit with very wealthy individuals or movie stars or sports athletes. Many times they don't go out and buy houses themselves. They actually hire an agent to purchase the house on their behalf. And a lot of times they won't be disclosed. So you'll know you're dealing with an agent, but you don't know who the principal is. You may find out at closing, and you may not. It may be that the agent is the one that completes the entire transaction. And then the last situation is where we have what's called an undisclosed principal. That is a situation where you're dealing with an agent and you don't even know that there's an agency relationship. You don't know that you're dealing with an agent. From your perspective, if you're the buyer, you think that the person selling the house is actually the owner, when in fact they're not only not the owner, but they're an agent. So you don't know that the agent is an agent, and you don't know, obviously, if you don't know that there's an agency relationship, you have no reason to believe that there's a principal involved. So that's what we called an undisclosed principal. We see this transaction a lot with a lot of the big retailers or big businesses in general. So if we have a big developer that's buying, let's say 100 acres of land, a lot of times they may send somebody out there and start the initial negotiations and maybe enter into a contract whereby the agency relationship will not even be disclosed. So you don't even know that you're dealing with an agent. The reason for that is pretty obvious, right? They don't want you as the seller to raise the price, right? If you know that you're dealing with Disney, for example, your $5 million lot may suddenly become $50 million. So that's the reason why that whole relationship is not disclosed, or the reason why that's done many times. But each of these types of relationships, the types of principals, create certain duties and certain liabilities for both the principal and the agent. So let's talk a little bit about authority. Authority is the power that the agent has to change the legal status of the principal. In other words, to bind or act on behalf of the principal. There are two types of authority. One's actual authority, which is the power that's conferred upon the agent by actual consent manifested by the principal to the agent. So either if I'm the principal and I hire you, I may have an express written contract, or it could be an oral contract that I have with you, but the authority is actual. I hire you to be my agent, so that's actual authority. And actual express authority is related to that. It's actual authority that's derived from either written or spoken words of the principal that's communicated to the agent. So that would be the most common. Most of the time, and again, going back to my real estate example, when you hire a real estate agent, you sign a listing agreement, and that listing agreement provides actual express authority to the agent to act on your behalf. And it also provides, or should provide, the scope of the authority that you have. So your authority may be limited. So in the case of the real estate agent, your authority is limited to selling my house. Or your authority may be more broad, right? You may have the ability not only to sell my house, but also to negotiate other business deals on my behalf. So again, this authority that I give you is going to dictate the scope of what you can and cannot do as an agent. There's a slide here that discusses really the contract liability when the principal is disclosed. In other words, if you're the third party, you know you're dealing with an agent, and you also know that the identity of the principal. So in this particular situation, if the agent has actual authority, then the principal is bound to the third party by the agent's actions. If the agent has apparent authority but not actual authority, then the principal is still bound to the third party, but the agent may have a duty to indemnify the principal. In other words, may have to provide or pay for any damages that the principal suffers as a result of your not having actual authority. And if the agent has no actual or apparent authority, then the principal is not going to be bound, and the third party may have a cause of action against the agent, and that's really based on a theory of implied, breach of the implied warranty of authority, or more than likely some type of misrepresentation. That's usually the claim that the third party would have against the agent. So again, we talked about express authority. Now we're going to talk about actual implied authority and apparent authority. Actual implied authority is actual authority inferred from words or conduct manifested to the agent by the principal. So in other words, I didn't expressly give you the authority, but it's inferred from the words that I speak or from the conduct that between the parties. And then there's apparent authority, which is power conferred upon the agent by acts or conduct of the principal that reasonably lead a third party to believe that the agent has such powers. So if in other words, if I introduce you as somebody that represents me, right? Even though I may not, tell anybody that you're my agent, or if I always bring you to my business meetings, if I allow you to negotiate on my behalf, that's apparent authority. I'm leading third parties to believe that as the agent, you have power to represent me. So you have to be very, very careful with apparent authority. If you have an agent and you believe that third parties are getting the wrong impression, that they believe that the agent can act on your behalf when in fact the agent cannot, then you have a duty to tell those third parties that the agent is not your agent, is not representing you, or does not have the authority to bind you as the principal. So that becomes very, very important. So that would be a situation in which silence would actually work against you, because you have a duty to speak and let somebody know that person does not have authority to represent you. We have another here slide that discusses the contract liability of an unidentified principal. So again, this is the situation where the third party knows that they're dealing with an agent, but they don't know the identity of the principal. So if the agent has actual authority, then the agent is bound to the third party, but so is the principal. So in other words, if that contract is breached, then the third party can either sue the principal or sue the agent. However, if the agent has actual authority, then the agent has the right to seek reimbursement from the principal for any liability to that third party. And I'm not going to go through each of those slides or the other two situations in detail, but you can follow the arrows there to see who's actually bound, who's got indemnity obligations, and so forth. Remember, though, under all of these scenarios, if the agent has no actual or apparent authority, the agent is always going to be bound to that third party, not the principal. So if the contract is breached, in other words, if the principal does not do or perform under that contract, then the third party can sue the agent, and the agent doesn't even have the right of reimbursement or the right of indemnity from the principal. The agent's going to be fully liable for that because, again, it's really obvious if you think about it. It makes common sense. The agent did not have authority, and therefore the agent is the one that's going to be liable. What about if we have an undisclosed principal? Again, this is a situation in which the third party doesn't know that they're really dealing with a principal. If the agent has actual authority, then both the agent and the principal are bound. Obviously here, eventually the third party will find out that there's a principal that's involved. Once you sue, I'm sure that the agent will disclose at that point the existence of the principal, and so that's how the principal gets brought into the lawsuit and is actually bound by that contract. If the agent has no actual authority, then again, same as what we saw in the prior slides, right? Anytime the agent acts outside of the scope of their authority, they're always going to be liable. What about the concept of delegation of authority? This is usually not permitted unless actually or apparently authorized by the principal. If the agent is authorized to appoint other subagents, the acts of these subagents are as binding on the principal as those of the agent. So in other words, really what this slide is trying to say is that if you are the agent, you cannot delegate the authority given to you by the principal to somebody else. In other words, you cannot hire subagents unless you're authorized to do that. If you are, then obviously you can. At that point, those subagents are representing the principal. They're not representing you as the agent. So any of their acts really are going to bind the principal. What's the effect of termination of the agency relationship on the authority? Well, first and foremost, it ends actual authority. So if obviously either party, whether it's the agent or the principal, can terminate the agency relationship at any time. So obviously, once the agency is terminated, so if I'm the principal and I terminate, and it may be that I terminate it, or it may be that it terminates due to the lapse of time, right? So let's go back to my real estate example. I listed my house with you. You're my agent. You're my real estate agent. And I list my house with you for 6 months. And so let's say that after 6 months, we have not sold the property. And so then the agency relationship, that listing agreement, expires due to the lapse of time. So unless we renew that agreement, you are no longer my agent, which means you don't have any type of authority. So the lapse of time, or me telling you that you're no longer my agent, actually ends actual authority. However, it may not end apparent authority. In other words, if you've been acting on my behalf for a while and third parties believe that you're my agent, the fact that I terminated you ends actual authority, but those third parties don't know that I terminated you, so they may still believe they have authority, and they may allow you to enter into contracts on my behalf. So it's very important that when you terminate an agent and that agent deals with multiple third parties, it's very important for you to notify those third parties that that agent is no longer your agent. So at that point, not only are you terminating actual authority, but you're terminating apparent authority by notifying those third parties with whom the agent had previously dealt. There's something called, in the slide before, talked about the second restatement, and this is the second restatement of agency, and there's another one which basically says, the same thing that I just mentioned, but there's also something called the third restatement, which basically says that the termination of actual authority does not by itself end any apparent authority held by an agent. Apparent authority ends when it is no longer reasonable for the third party with whom an agent deals to believe that the agent continues to act with actual authority. So again, what's reasonable, that could be a problem. So especially if your agent has been your agent for a long period of time. So in order to avoid any misunderstandings, any issues, any potential liability, safest thing you can do is let those third parties know that the agent is no longer your agent and therefore doesn't have authority to act on your behalf. What about the concept of ratification? That's an affirmation by one person of a prior unauthorized act that another has done as her agent or as her purported agent. So in other words, let's say that you really are not my agent. I never gave you any type of authority, but you hold yourself out to be my agent and you enter into a contract on my behalf. And let's say I find out about that contract. And when I look at the contract, I say, you know what? This really isn't that bad. This is a pretty good contract. So then you decide to ratify that contract. In other words, you affirm it. You say, you know what? That's fine. I'm okay with that. So even though the act itself was unauthorized, you can ratify and make that contract valid, which otherwise would be invalid because the agent had exceeded their authority. If you ratify the contract, then you as the principal become liable on that contract. If you don't ratify the contract, then the agent would be liable on that contract since they did not have authority to act on your behalf. Now, there are some fundamental rules of contractual liability. So if we have a disclosed principal, that disclosed principal is contractually bound with a third party if the agent acts within her actual or apparent authority in making the contract on the principal's behalf. It's very similar to that slide we had seen before with the arrows. If we have a partially disclosed principal, then that partially disclosed principal is contractually bound with a third party if the agent acts with her actual or apparent authority in making the contract on the principal's behalf. So again, under either of those scenarios, the principal is always going to be liable. If we have an undisclosed principal, again, the person doesn't know that they're dealing with an agent and doesn't know that there's a principal that's involved, then that undisclosed principal is contractually bound with a third party if the agent acts within her actual authority making the contract on the principal's behalf, which really makes sense, right? I mean, whether the principal is disclosed or not doesn't really matter. The only difference is that the person signing the contract on the other end doesn't know that they're dealing with a principal. If there's a breach, obviously the agent is likely to be sued in that scenario, but it doesn't make the principal any less liable under that contract. So we just discussed contractual liability. What about tort liability? Tort liability is going to depend on the agent's conduct. So in other words, if the agent's tort was authorized or, authorized is actually the best word. So give you an example. I'm the principal. I know that you're going to lie on my behalf, or maybe even I direct you to lie on my behalf. Then at that point, right, the principal is the one that's going to be liable to the third party, not the agent. Now remember, the agent may still get sued. And if the agent gets sued, then they have a right of indemnity from the principal. In other words, the principal has to pay for my legal fees and for any damages that I have to pay the third party as a result of that tort. Now, if we're talking about an employer-employee relationship, and a lot of employer-employee relationships are principal-agent relationships, the employee's tort, let's assume that the employee's tort is unauthorized, but it's done within the scope of employment. So in other words, going back to the same misrepresentation, I lied to you, but my employer did not tell me to lie and did not know that I was going to lie or make some type of misrepresentation, right? Let's say we're talking about a car dealership, right? And so you're an employee of the dealership and you lie to a customer about the mileage in a car. And as the dealer, I don't know that you lied and I never told you to lie. So that would be an employee's tort that's unauthorized, but it is within the scope of employment. If that's the case, then the principal is liable to the third party, and so is the agent. And not only that, the agent has to indemnify the principal for any damages, including attorney's fees, that the principal has to spend as a result of the misrepresentation. So that's just an example. What if the employee's tort is outside the authority and scope of employment, or if it's an independent contractor's tort, which is unauthorized? Well, if that's the case, then the agent is the only one that's going to be liable to the third party. And that one really makes sense. In particular, if we're talking about independent contractors, just like the name implies, are independent from the employer or the principal, and therefore they are the ones that are personally liable, not the principal. So let's talk a little bit about the tort liability of the principal. There is direct liability of the principal. So a principal is liable for his own tortious conduct involving the use of agents. And that's pretty obvious. You're always going to be liable for your own conduct. If you use agents, obviously the agents are acting on your behalf. So as long as it's your tortious conduct, whether it's done by you or by your agents, whether with your knowledge or under your direction, you're always going to be liable. So if they are authorized acts of the agent, then the principal is liable for torts that you authorize another to commit or that you ratify, right? You know they're going to do it and you're good with it. If they're unauthorized acts of the agent, then a principal is liable for failing to exercise reasonable care in employing agents whose unauthorized acts caused the harm. So that's where the liability or the danger is for the principal. What about vicarious liability of the principal for unauthorized acts of the agent? We have a Latin term here, but it's a doctrine called respondeat superior. And what that means is that an employer is liable for unauthorized torts committed by an employee in the scope of his employment. So again, this is a situation where the employer does not know that an employee is engaged in some type of tortious conduct or behavior, doesn't condone it, doesn't know about it, but they are still liable as long as it is done or that conduct is within the scope of the employment. An example of that would be, let's say I'm a UPS driver and I'm driving down the road and I'm texting while I'm driving and I don't see a pedestrian and I run over a pedestrian and kill him. At that point, that is an unauthorized tort. Obviously, as the principal or as the employer, I did not authorize you or ask you to kill someone. Obviously, that's an accident, so it's a tort. You were negligent, right, which is a tort. And at that point, the employer is going to be liable because you were within the scope of your employment. You were driving the UPS truck. What about when agents act with apparent authority? So principal is liable for the torts committed by an agent in dealing with third parties while acting within the agent's apparent authority. So again, this is that situation where you do not have express authority, but you've always acted as my agent. I know that you act as my agent. I've never said anything. So you have apparent authority to act on my behalf. Or that could also happen, right, when I terminate you as my agent. I tell you you are no longer my agent, but I don't notify third parties. So those third parties that are used to dealing with you believe that you have the authority, which is apparent authority. So in those situations, the principal is liable for the torts that the agent commits. What about independent contractors? This is very, very important because a principal is usually not liable for the unauthorized torts of an independent contractor. So this is why a lot of employers will try and classify an employee as an independent contractor. What's important to take away from this is it doesn't matter what you call the employee. So it doesn't matter whether you call him an employee or an independent contractor. What the courts are going to look at is how do you treat that employee? Do you treat that person as an employee, meaning do you exercise control over how and when they perform their work? So in other words, if I tell you you have to start work at 8 a.m. and you have to leave at 5 p.m. and you get 1 hour of lunch between noon and 1 p.m., then if that's the case, you're going to be an employee because I'm exercising control over your means and methods of performing the work. If you're an independent contractor, I do not have that right. So I can tell you, hey, you have to complete this job by April 1st, but you as the independent contractor decide how you do that. You decide your hours of work. So you decide what time you come into work, what time you leave. You decide when you take your lunch. And so those are some of the factors that the courts will look at to determine whether you are an independent contractor or an employee. Obviously, from an employer's perspective, for more reasons than one, they're going to want you to be an independent contractor. Again, if you're an independent contractor, you're going to be liable for your own torts, and vicarious liability or respondeat superior will not apply. It's also beneficial to employers from a tax perspective. There's tax benefits to having you classified as an independent contractor versus an employee. What about the criminal liability of the principal? If they're authorized acts, then the principal is liable if he directed, participated in, or approved the criminal acts of his agents. So under any of those circumstances, the principal will be liable for the criminal acts just as if he had committed those acts himself. If they're unauthorized acts, then the principal may be liable either for a criminal act of a managerial person or under liability without fault statutes. So depending on, there are certain types of crimes that do not require fault, and therefore you may still be liable. But if the employee was acting without authority or was not authorized to commit those acts, then the circumstances in which the principal is going to be liable from a criminal perspective are going to be limited in scope. We already talked about contract liability. Oh no, actually, I'm confusing it here. We didn't talk about we talked about contract liability of principals. Now we're going to talk about the contract liability of agents. So again, and we did talk a little bit about this before, but if the principal is disclosed and the contract is authorized, the agent is not normally going to be liable because they're not a party to that contract, right? They're actually entering into that contract on behalf of the principal. This will also be true if the contract was not authorized, but it is later ratified by the principal. Then again, the principal is the one that's going to be liable. What about for unauthorized contracts? If an agent exceeds her actual and the parent authority, the principal is not bound by the agent. Is not bound by the contract, but the agent may be liable to the third party for breach of warranty or for misrepresentation. In fact, there could be a negligent misrepresentation count where no fault is required, right? Where you knew or should have known that you did not have authority to enter into that contract, and in so doing, you exceeded your scope of that authority, and therefore you're going to be liable for that contract or any damages that the third party suffers as a result of your lack of authority. Disclosed principle, again, where if the agent assumes liability, an agent may agree to become liable on a contract between the principal and the third party, right? So we call that an assumption of liability. Normally you don't have liability, but you could assume liability. Why you would ever do that, I have no idea. Obviously, if you're going to do that, you're going to charge the principal a premium in order to do that because now you're becoming liable, right? So I guess if you get paid enough money, I guess you would, but there's no reason to do that. If you have an unidentified or partially disclosed principal, an agent who acts for a partially disclosed principal is a party to the contract with the third party unless otherwise agreed. So what that means is that the agent then is going to be liable on that contract just like the principal. Now, you would have a right of indemnity, right, if that contract is authorized. If the principal is undisclosed, right, so we have an agent who acts for an undisclosed principal, then that agent is going to be personally liable on the contract to the third party, which makes sense, right? If I'm the what we'll call the innocent party, if I'm the innocent party, I enter into a contract with you. I don't know that you're an agent, so obviously I don't know that there's a principal involved. Then, if there's a breach of contract, I'm obviously going to look to you for relief. You're the one that I negotiated with. You're the one I've been talking to. You're the one that signed that contract. And now, you as the agent, you may have a right of indemnity against the principal, but that's between you and the principal, right? As the third party, I can actually go after you as the agent since you are the one that I've dealt with. what about non-existent or incompetent principal? So a person who purports to act as an agent for a principal whom the agent knows to be non-existent or completely incompetent is personally liable on a contract entered into with a third person on behalf of such a principal. So in other words, if you lie, right, if you say that you're my agent when in fact you're not, or let's say that you say you're an agent for John Doe when John Doe doesn't exist. So in other words, you're making all of this up to try and trick the third person into believing that there's a third party. So if there's a problem, they don't sue you. They try and sue this or chase after this non-existent party. Or if you know that the principal is completely incompetent, then obviously you're the agent. You only have the authority that the principal has. So if the principal is incompetent and unable to enter into contracts, then you can't either, because you have as much authority as the principal has. So you're going to be personally liable in both of those situations. And again, both of those are situations that make sense. The idea of the law as it pertains to third parties is to protect the third party, right? If you're lying to me and I have no reason to know that you're lying to me, either the fact that a principal does not exist and you just made up a name and made up an agency relationship, or if the principal is incompetent, I don't know that. So obviously, why should I bear the harm when I have no idea? You're the one that lied to me, so you're the one that needs to bear that risk. So as the agent or alleged agent, because there may not be an agency relationship, you're going to be liable. Again, authorized acts, the agent is liable to the third party for his own torts. That one's pretty obvious. Anytime you commit a tort, you're always going to be liable, right? So, and it may be that the principal is liable as well, but as the agent, you're always going to be liable for your own tort. If the act is unauthorized, then the agent is liable to the third party for their own torts. But at that point, if the act is unauthorized, then the principal may not be liable, depending on the situation, right? If you're in an employer-employee relationship and you're acting within the scope of employment, even though the act is unauthorized, the principal may still be liable. So those are all situations where you have to be careful on both ends, whether you're the principal or the agent. You have to be very vigilant. So what are the rights of the agent against the third party? Well, if we have a disclosed principal, the agent usually has no rights against the third party. And that's pretty obvious, right? I mean, the third party knows that you're an agent, they know who the principal is, and every single act that you engaged in, you did it on behalf of the principal, and the third party knew it. And therefore, you have no rights against that third party. Any rights, any claims, any obligations, all belong to the principal. What if there's an unidentified or partially disclosed principal? Well, the agent may enforce the contract against the third party at that point. Well, the agent is also going to be liable under that contract, right? So it's a two-way street. If you're the agent and you're going to be liable, then obviously you have some rights and duties under that contract, and it works both ways. So you could actually enforce the contract against the third party. If you're in an undisclosed principal relationship, then the agent may enforce the contract against the third party. And again, that one is also obvious. In an undisclosed principal relationship, the third party cannot go after the principal. They usually don't know that there's a principal. They're going to go after you. And so obviously, since you're the one that's on that contract and responsible for that contract, then you can enforce that contract. So it goes, again, it's a two-way street. So if the third party breaches the contract, then you as the agent can enforce that contract and sue and seek damages or specific performance or whatever remedy it is that you're looking for. And this actually concludes this chapter. If you have any questions, please let me know. This particular week, I know we're scheduled to cover 3 chapters, but we're only going to cover 2. We will not cover chapter 30. We're only going to stick to chapter 20 and 21. And I will actually record and upload the lecture for chapter 21 tomorrow.